Hey.
What's up, man? How you doing? Good.
Hey, guy.
Hello.
How you doing?
Good. Who's is that?
My daughter. Does she look like me? No. I just pulled her out of the back of that car.
Okay.
So really quick, we were coming to take this turn here.
Okay.
She was asleep and passed out in the car with her feet out the window. Her
With
flashes
her feet
were
out the window?
Yeah, her feet were up out of the
baby
window.
was screaming
so
in the
he's
back
like,
seat.
"Are you okay? Are you okay?" And she wasn't waking up, so we pulled the car and he went and got the baby. Was crying and she was completely out of it. So he took the baby out, feeding the baby, but yeah, she's definitely not very. You could take it from here, but we didn't want to leave.
Yeah, no, for sure. You have her keys?
I have her keys. We took the car.
So I was on my way home from just working the soccer stadium, and I seen these people here with a baby. I'm like, okay, was it an accident? So
Okay.
Baby's a week old.
So
Got it.
Is it her baby? Yeah.
Hers. I took it out of the car.
Crying. She was passed out.
So I'll take two. Let me just start up first.
Are we waiting for somebody else?
Yeah, just give me a second. I appreciate your feeding the baby. Obviously, you know what you're doing, so.
What's your name? What's your name?
Charlie, do you want also for?
Do you need fire rescue?
Yes, sir. Copy.
You have your ID with you?
Copy.
No, I don't.
You don't have any ID with you, so you're driving without an ID?
Yeah, I am.
Okay. Awesome.
You alright?
No.
What's going on? Where are you coming from?
1 week old. She said that.
She said?
That's what she said. She doesn't look like she had a kid a week ago, though.
Maybe.
I hope it's hers.
It should be. She looks like it's possible. The bottle was with the baby?
In the back seat. The baby was locked in the back. I had to get her out, kid out. I don't know if it's a boy or girl, but it was 100 degrees in the back of that car. I don't know how long she's been here.
Oh, the car was off.
Just like that, with her feet hanging out the window.
Hello? Where were you at before here?
Right, I don't know what
Can you look in that bag and
No,
see?
no. Just right now we're not going to go in her car. We're waiting for FHP to get here. I will work on getting more milk for the baby, okay? That's why I'm already looking. Just go back there. Just go over there, sir. I don't want you to get into an argument.
I know.
I keep in the car too. I don't want to run around and shit.
Yeah,
Stop playing with me. Go ahead.
I'm not doing anything.
Where did you say you were before here?
I ain't saying nothing.
What happens to the babies, B?
We'll have them come. There'll be two people that come, and then ideally, we'll try and get a hold of a family member to come and get the baby.
I mean, has she tried to call anybody? I don't know.
Where are you coming back from?
I ain't coming back from nothing.
Well, you're driving somewhere. So, I'm trying to figure out where you were before here.
All right.
So, where were you?
I don't know.
You don't know where you were?
I don't know.
You at a restaurant, beach?
Well, I used that term loosely. You had to.
A week old? You got that out of her?
Thought,
What's up?
you thought.
We thought? Thought what? Where were you before here? How did you get here? Where do you live? You what? Who's that tag come back to? What city? What city do you live in? Hello?
Do you know where you're at? Where are you?
Where are you right now? You know what city you're in?
Hi, how are you? So they found her, I guess, like just sitting in the car with her purse.
Sustain open.
You're holding that?
Yeah, sustain open.
I promise you're not closing this door.
All right, and what you gonna do?
You're not closing
What
this
you
door.
gonna
Relax, or you're gonna go in handcuffs.
What? Okay,
Sit down,
put
sit
me in handcuffs.
Sit
Put
down.
me in handcuffs. Please put me in handcuffs.
Sit
Please put me in handcuffs. Don't. Oh God, look at that. Look at that.
I have no idea.
Oh, but you don't. Dumbass.
It's probably gonna be a DCF call
Oh, for sure.
because we have no idea
Yeah.
whose baby this is or anything. I'm not
What you gonna
Te
do?
amo, mi amor.
What you gonna do?
Yeah.
You so dumb. Yeah, you dumb. Oh my God.
Any family members?
We have no idea. We don't even know her name.
Out of her. Where's your phone?
I can give you several.
Okay, we need someone to come get your baby. Where's your phone?
All right.
Here in the backseat.
Yeah. Where's your cell phone? You get your cell phone?
Is the pink phone in the back yours? Can you grab your phone behind the seat? Who can we call? What family member?
We need to call a family member for your baby.
All right. Okay.
Hey, where's your
You
cell
know the
phone?
phone number? Can you grab your phone in the back? This the pink phone behind you? Can you grab your phone behind you? Put the pink phone right behind you. Get it? Just reach back. Can you do that for me? Alright, let's do it. You know a phone number off the top of your head? Your mom's phone number, family member.
We don't try and take custody of the children ourselves. We'll try and get a family member to come out here. But I need FHP to respond, and they're on the way.
Alright.
And I'm glad you guys came just to like make sure that the baby's okay. But
Alright, we'll take it from you.
Go. What are you doing?
We're just gonna, we can hold her unless you want to hold her.
I need some milk.
We don't have that, obviously.
I don't know if she has more. Maybe she has more in the car.
I'm my best at it.
Alright, perfect.
I got hold 3 of these.
you can sit back down. They're just here to help you out. You don't have to. I know. Put the burden on you.
No, you kidding me? It's a kid. No
Hey,
bird.
natural grandpa right here.
No more strings.
Hey, nobody claims her. We'll take her. I don't know if it's a boy or girl.
I mean, they all look the same.
I know. And
Hello? I'm asking you a question. Who can we call? Put her back in the car seat.
Sit down.
Stay in the
Sit
car.
down.
Car seat and take it
Sit down in the car.
Alright, what you gonna do?
Hey.
Calm it down.
Relax.
Oh.
Sit down. You form.
Get in the car.
What's yourself? You good?
Who are you to her? Her aunt? Okay. That's her? Okay. I have a few questions for you, so I'm gonna roll the window back up. Well, she told us. I can ask her again.
Make sure you ask her in front of her
Yeah.
child. Know if
I'm
you're,
her cousin.
I understand, but you're not the legal guardian. So we need to at least have her give authorization that the baby can go with you for the night, at least.
Yeah.
Right? So I need him, especially on his body on camera, to have her telling you that because the child is hers,
Yeah.
right? But we always like to put the child with a family member before we try and take her in this custody and sleep, right?
I grew up with her. She's my little cousin.
Okay.
My uncle.
Where does she live?
Miramar.
In Miramar? You know
Who's
where her
this?
house is?
I don't know where her house is.
Who's he? Is he with you?
Yeah, that's my boyfriend.
Okay.
You said you don't know where her house is?
I know she lives in Miramar, but I don't know
You have a
exactly
Miramar
where.
address, so she says she still lives there.
Yeah.
You said she's your cousin.
Emily, so you're okay? It's your cousin here. Are you okay with your child going with her, with your cousin? Yes? Okay.
I love you.
What's your baby's name?
What's the baby's name? Malachi Angel
I
Colazo.
don't even know how to spell that first name.
So here's the thing. She's under arrest, right? I'm Sergeant Correa, right? This officer Dunn. If I arrest you, Captain Alfano, okay? Roll her window. So at this point, she's under arrest for DUI, battery on a law enforcement officer. Obviously, she's extremely intoxicated.
Yeah, I see.
She was passed out here drunk in a car, and a good Samaritan came here. She had her feet hanging out the window and hazard lights on the car on the side of the highway. So they came, they turned the key off, and the baby was in the back seat screaming and crying. So luckily some good Samaritans stayed here, they fed the baby a bottle, and they waited for us to get here. Luckily, and like it could have been even worse, like especially if someone's not paying attention, ran in the back
Even
of
that,
her.
or they could have took the baby and kidnapped the baby and.
They could have kidnapped the baby, anything. She was out.
Yeah.
You guys are, do you have children?
I have two. I have a
Okay, so you-
23-year-old and I have a 60-year-old.
So you at least know how to take care of a child
course,
for the
yeah.
night or something.
Yes.
This whole thing is extremely documented. We're all on body worn cameras. The biggest thing is, would you mind? I'll talk to her. Just thank you, sir. The thing is, we want to get the child with the next closest family member that we possibly can, like I explained before.
The baby's in good hands, I promise you.
But Child Protective Services is definitely going to be getting in touch with you. You know, the cell phone number you gave, that's
That's
Sure you
my-
answer it.
Yes.
Okay, they might even be calling them tonight. Okay, that's very possible. The address that you gave on your driver's
That's my
license, most current address, that's where you're going tonight?
Yes.
Okay, you confirm that, you got that?
I live in High. It's Miami Lakes, but it's considered. It's like the borderline of Broward.
But it's the address on your license, right?
So, I guess we just have to leave someone safe. How old's her father?
My uncle he's over 50. He's had like 2 heart surgeries already. We've been trying to get her help. She's been in
I
and
saw
out of
her
rehab.
for what? Alcohol abuse or drugs or what?
Alcohol, you name it. We've been trying and trying with her for many, many years. She has a lot of mental problems.
And the guy, the father, you have no
I don't
idea
know
who he
the
is?
dad. I don't know who the father is.
All right,
But
so
we've been trying to help her, and it's hard. People with addiction, it's like they get.
do you know what she's addicted to?
Alcohol.
Do you know
My
she does
understanding-
other drugs?
I don't know if she does any type of drugs. I know that the alcohol, she's had that issue since she was like a teenager. So we've been trying to get her help. He's been trying to get her help. It's hard. It's hard to help someone with an alcohol addiction. I'm actually was telling her to you, I'm going through the divorce because my ex-husband is alcoholic.
Okay.
So I had to remove myself from that situation.
Do one last thing before they leave. Give me 1 second. Just go to your car so I can talk to him for 1 second. Thank you.
All right, Emily. I'm now requesting that you submit to a lawful test of your breath for the purpose of determining its alcohol content. No? Okay. If you refuse to take the test I've requested of you, your driving privilege will be suspended for one period of 1 year for a first refusal, or 18 months if your driving privilege has been previously suspended for refusing to submit to a lawful test of your breath, urine, or alcohol, or blood. Additionally, if you refuse to take the test I have requested of you, and if your driving privilege has been previously suspended for refusal to submit to a lawful test of your breath, urine, or blood, you will be committing a misdemeanor in addition to any other penalties which may be imposed by law. Refusal to submit to the test I have requested is admissible in the evidence in any criminal processing. Do you still refuse to submit to the test?
Yes, I refuse.
Okay.
Imagine you're driving
There's
down
a
a
bathroom
quiet
in there.
residential road in the middle of the day. There's no crash, no flashing lights, no obvious emergency. Just a car stopped in the middle of the street, engine still running, driver slumped forward at the wheel. At first glance, it looks like a medical issue, maybe exhaustion, maybe someone pulled over and nodded off for a moment. But then someone looks into the back seat and sees something that instantly changes the situation from a welfare check into a criminal investigation. A baby, alone, buckled into a car seat, while the driver is unconscious. This is the kind of call that law enforcement treats with extreme seriousness, not because of what might have happened, but because of what could have happened at any second. A running vehicle in the middle of the road is already a hazard. An unconscious driver elevates that risk, but when an infant is involved, the legal stakes multiply immediately. This is no longer just about impaired driving. It becomes about duty of care, reckless endangerment, and whether a child's life was placed in danger through criminal negligence. On September 2024, officers in Kent, Washington were dispatched to what initially came in as a welfare check. Multiple 911 callers reported a woman passed out in the driver's seat of a vehicle blocking the roadway. What made the call urgent wasn't just the obstruction or the concern for the driver's health, but the reports that a baby was inside the car. Witnesses would later say the woman had been unconscious for at least 15 minutes with the engine still running. That detail matters legally. Time is a critical factor in child endangerment cases. 15 minutes isn't just a momentary lapse. It establishes duration. It suggests sustained risk. And when prosecutors later look at a case like this, they don't ask whether harm did occur. They ask whether harm was reasonably foreseeable. An idling vehicle can roll. It can overheat. It can be struck by another car. And an infant strapped in the back seat has no ability to escape any of those outcomes. When first responders arrived, firefighters reached the vehicle before police. That's significant. Fire crews are trained to assess medical emergencies first, not criminal liability. Their initial role is stabilization and safety. They woke the driver and evaluated her condition. According to reports, she appeared physically uninjured, but immediately showed signs that raised red flags, slurred speech, confusion, and an inability to answer basic questions. Officers also noted the odor of intoxicants and an open bottle of alcohol on the front seat. At this point, the legal trajectory of the incident was already set. In Washington state, as in most jurisdictions, DUI investigations do not require erratic driving or a traffic stop. A person does not have to be moving to be considered in actual physical control of a vehicle. An engine running, a driver in the seat, keys present, that's enough. And when impairment is observed, probable cause begins to form quickly. But what elevates this case beyond a routine DUI is the presence of the infant. Prosecutors don't treat children in vehicles as passive passengers. Under the law, parents and guardians have an affirmative duty to protect their children from harm. Placing a child in a situation where a reasonable person would recognize a substantial risk of injury can constitute reckless endangerment, even if the child is never physically harmed. Witnesses at the scene reportedly removed the baby from the car before officers arrived, consoling the child while emergency services assessed the situation. That intervention likely prevented further danger, but legally, it does not erase the risk that already existed. Courts consistently hold that third-party intervention does not absolve the original actor of responsibility. The question remains whether the danger was created in the first place. Once the driver was medically cleared, police transitioned from welfare response to enforcement. Officers observed signs consistent with intoxication and discovered that the woman's license was suspended. That fact adds another layer of criminal exposure. Driving with a suspended license is not a paperwork violation. It indicates a prior legal determination that the individual should not be operating a vehicle at all. When combined with impairment in a child passenger, it strengthens the argument that the behavior was not accidental, but recklessly disregardful of safety. From a legal standpoint, this case sits at the intersection of multiple statutes: driving under the influence, driving while suspended, reckless endangerment, and domestic violence-related charges tied to child safety. In Washington, reckless endangerment involving a child can be charged as a domestic violence offense because the victim is a household or family member. That classification carries enhanced consequences, including mandatory court appearances, potential protective orders, and long-term implications for custody and parental rights. At this stage in the encounter, officers are not debating guilt. They are documenting facts, they are preserving evidence, and they are making decisions based on statutory obligations. When a child is involved, discretion narrows significantly. Officers are often required to make an arrest once probable cause is established. Failure to do so can expose departments to civil liability if harm later occurs. This is where many viewers misunderstand police discretion. From the outside, it can look harsh, it can look sudden. But legally, the system is designed to err on the side of child safety, not parental benefit of the doubt. The law does not require officers to wait until tragedy occurs. It requires them to intervene when risk becomes unacceptable. As this situation continues to unfold, the focus shifts from what happened in the car to what happens next. How officers assess impairment, how custody decisions are made in real time, and how a single lapse in judgment can spiral into multiple felony-level consequences. This case is not about punishment for mistakes. It's about where the legal system draws the line between poor judgment and criminal endangerment, especially when the life of a child is involved. At this point in the incident, the situation has fully transitioned from a welfare concern into a criminal investigation. The driver's awake. The child is safe for now, and the officers are no longer asking whether a crime occurred, but which crimes apply and how they must proceed under the law. This is where DUI cases involving children diverge sharply from standard impaired driving arrests. In a routine DUI, officers focus on impairment indicators: speech, balance, odor, admissions, and physical evidence like open containers. When a child is present, those same indicators carry far greater legal weight because they establish not just impairment, but reckless decision-making while responsible for another human life. In Washington state, A driver does not need to be observed actively driving to be arrested for DUI. The legal concept at play is actual physical control. If a person is in the driver's seat, has access to the ignition, and the vehicle is operable, they can be charged, even if the car is stationary. In this case, the engine was running, the vehicle was stopped in the middle of the roadway, and the driver was unconscious. That combination alone satisfies the threshold, but impairment must still be established. According to reports, officers observed slurred speech, confusion, and an inability to answer basic questions. These are classic DUI indicators. The smell of intoxicants and the presence of an open alcohol bottle in the front seat further strengthen probable cause. At that point, officers are legally justified in making an arrest, even before any chemical testing is conducted. What many people don't realize is that DUI cases don't hinge solely on breath or blood results. Observations matter, officer testimony matters, witness statements matter. And in this case, multiple independent witnesses reported the woman had been unconscious for at least 15 minutes. That duration becomes critical when prosecutors later argue risk exposure. Time equals danger. 15 minutes of unconsciousness while responsible for a child is not viewed as a brief lapse. It suggests sustained incapacity. And under the law, sustained incapacity while responsible for a dependent child crosses into reckless endangerment territory. Reckless endangerment requires proof that a person engaged in conduct that created a substantial risk of death or serious physical injury. It does not require intent to harm. It does not require actual injury. It only requires that a reasonable person would recognize the danger. Leaving an infant strapped in a running vehicle while unconscious in the middle of a roadway easily meets that standard. That's why this case includes a domestic violence-related reckless endangerment charge. The term domestic violence often confuses people. It does not require physical assault. It applies when the victim is a family or household member. A child qualifies automatically. The classification increases the seriousness of the charge and triggers mandatory procedures, including potential involvement from Child Protective Services and family court. The suspended license adds another layer of legal exposure. Driving with a suspended license indicates that the driver was already prohibited from operating a vehicle. That prohibition exists because of prior violations or court orders. When someone drives anyway, and does so while impaired and responsible for a child, it reinforces the prosecution's argument that this was not a momentary mistake, but a pattern of disregard for legal boundaries. Another important element here is witness intervention. Passers-by removed the infant from the vehicle and comforted the child before officers arrived. While that action likely prevented immediate harm, it does not mitigate the underlying offense. Courts are clear on this point. The crime is complete once the risk is created. Intervention by third parties does not retroactively erase criminal liability. In fact, witness involvement can sometimes strengthen a case. It provides corroboration, it establishes timelines, and it demonstrates that the situation was alarming enough that ordinary citizens felt compelled to act. Prosecutors often rely heavily on neutral witnesses to counter defense claims that officers overreacted or misinterpreted events. Once the driver was medically cleared, officers were left with limited discretion. In cases involving child endangerment and DUI, many departments operate under mandatory arrest policies. These policies exist because failure to arrest in high-risk child cases has historically led to severe consequences when children were later harmed. From a liability standpoint, officers are expected to intervene decisively. This is also where custody considerations come into play. Officers on scene must immediately determine what happens to the child. A parent under arrest cannot retain custody at that moment. Law enforcement must ensure the child is placed with a safe and appropriate caregiver or transferred to protective services if no suitable option exists. These decisions are made quickly, often under pressure, and are guided by statutory protocols rather than personal judgment. At this stage, the driver's cooperation or lack thereof becomes largely irrelevant. Once probable cause exists for DUI, reckless endangerment, and driving while suspended, the arrest is procedural. Officers are not negotiating outcomes, they are executing legal obligations. What follows next is often the most misunderstood part of cases like this: the stacking of charges. DUI is one offense. Driving while suspended is another. Reckless endangerment involving a child is separate. Each charge addresses a different legal harm. Together, they paint a picture of cumulative risk rather than a single bad decision. As the investigation continues, attention shifts from the roadside to the courtroom. Prosecutors will later evaluate whether additional charges apply, whether aggravating factors are present, and how the presence of an infant affects sentencing recommendations. In many jurisdictions, DUI cases involving children result in enhanced penalties, mandatory treatment programs, and long-term consequences for parental rights. This case is no longer just about a driver who passed out. It is about how the law responds when impairment intersects with parental responsibility, and where society draws the line between error and endangerment. By the time this case reaches the judicial system, its trajectory is largely predetermined. DUI cases involving infants are treated as high-risk matters, not because of public outrage or media attention, but because of long-established legal precedent. Courts across the United States have consistently ruled that children lack the ability to protect themselves, which places an elevated duty of care on any adult responsible for their safety. When that duty is breached through intoxication, the legal response escalates rapidly and decisively. One of the first and most immediate consequences of this arrest is mandatory child welfare involvement. In Washington state, law enforcement officers are legally required to notify Child Protective Services whenever a child is exposed to substantial risk. Importantly, CPS does not need proof that the child was physically injured. Exposure alone is sufficient. The risk itself becomes the harm. This distinction matters because CPS operates independently from the criminal justice system. While criminal court focuses on guilt and punishment, family court focuses exclusively on safety and prevention. Even if criminal charges are later reduced, dismissed, or pled down, CPS involvement does not automatically disappear. The two processes move on parallel tracks, governed by different standards and different goals. In family court, the question is not, did a crime occur? But rather, is this child safe right now, and will they be safe tomorrow? That lower threshold allows the court to impose protective measures long before criminal responsibility is fully adjudicated. These measures can include supervised visitation, mandatory substance abuse assessments, parenting education programs, or temporary placement with a relative or foster caregiver. Judges also examine risk recurrence, not just isolated behavior. The presence of an open container in the front seat, a suspended driver's license, and the length of time the driver was unconscious all become aggravating factors. When multiple risk indicators converge in a single incident, courts are less inclined to view the event as a momentary lapse in judgment. Instead, it begins to resemble a pattern of instability. Another legally significant detail is the location of the incident. This was not a private driveway or a parked vehicle in a secluded area. The car was stopped in the middle of a public roadway, engine running, obstructing traffic. This introduces an additional layer of public danger. Prosecutors routinely emphasize this point because it demonstrates that the risk extended beyond the child and into the broader community. A vehicle blocking a roadway creates the potential for secondary collisions, pedestrian injury, or aggressive evasive maneuvers by other drivers. The law does not wait for those secondary harms to occur. Creating the conditions for foreseeable danger is enough to establish criminal liability. The domestic violence reckless endangerment charge also carries long-term consequences that many defendants do not anticipate. While it does not imply intentional abuse, it can affect custody determinations, firearm ownership rights, housing eligibility, and future court proceedings. Domestic violence designations are difficult to expunge and often follow individuals long after the original case is resolved. Perhaps the most difficult reality for defendants to accept is that positive outcomes do not negate dangerous decisions. The baby was removed safely, bystanders intervened, no crash occurred, no medical emergency followed, but criminal law does not operate on luck, it operates on risk creation. Courts are explicit about this principle. If legal consequences depended solely on harm actually occurring, enforcement would always come too late. The law intervenes precisely because waiting would be unacceptable when vulnerable individuals, especially infants, are involved. Cases like this are frequently used in training for law enforcement officers, prosecutors, and child welfare professionals. They sit at the intersection of criminal law, family law, and public safety. They demonstrate why welfare checks exist, why bystander intervention matters, and why officers are trained to escalate quickly when children are present. This case also underscores how ordinary moments can become criminal matters when responsibility intersects with impairment. There was no high-speed chase, no dramatic confrontation, no visible violence. Yet the legal consequences are severe because the risk was severe. In the end, this incident is less about alcohol and more about accountability. The law draws a clear and uncompromising boundary. When an adult assumes responsibility for a child, personal impairment becomes a public concern. The moment that impairment compromises safety, intervention is no longer optional. The takeaway here is not moral condemnation, it is legal reality. Parenting while impaired is not treated as a private mistake. It is treated as a preventable risk with potentially irreversible consequences. And once that line is crossed, the system responds swiftly, decisively, and with the child's safety as its only priority. If you were the responding officer, would you have had any other choice? Or does the law leave none at all?